Welcome to the Joint Veterans Endorsement Interviews for Judicial Candidates. We would like to thank our sponsors, Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds from Department 29. Let's review the rules and format. First, the panel members will introduce themselves by stating their names and the organization they represent. Next, each candidate will introduce themselves. Please include the office you are running for and explain why you are seeking that position. We will then proceed to the interview portion. Each candidate will have 1 minute to answer each question. When you have 30 seconds remaining, we will indicate. When your time has expired, you may finish your sentence, but then you will be asked to conclude. Panel members will not be permitted to ask follow-up questions. After all panel members have completed their questions, each candidate will be given 1 minute to make a closing statement. Thank you. First, let's start with introducing the panel members and then the candidate.
Good afternoon. It's Martin Walker, Nevada Veterans Association.
Yadasha Jones, Veterans in Politics.
Andre Haynes, Armed Forces Chamber.
Good morning. J.P. Edwards, Armed Forces Chamber. Frank Friends, Veterans in Politics and Court Observer.
Good morning. Thank you very much for having me here this morning. My name is Michelle Leavitt, and I'm a District Court Judge in Department 12 in the 8th Judicial District Court.
Judge, please tell us why you are seeking this position.
I've been on the bench for 27 years. I'm in my 24th year in district court. Most of my adult life has been spent in public service. I love the work that I do. Right now I have an all criminal docket, wherein half of my docket are homicide cases. Myself and 3 other judges, we do all the homicide cases that are filed in the 8th Judicial District Court. I think there's more work to be done. I love what I'm doing, and that's why I'm running to be reelected.
Wonderful. Thank you very much. We're going to start the questions with Frank Friends.
How you doing, man? My name is Frank Friends, Veterans in Politics. So on average, criminals commit about 11 crimes before they commit their first homicide, which is what you deal with. We also have the death penalty in the state of Nevada, but yet we don't use it as a deterrent to stop these things from happening when we have clear cases like the Home Depot shooting and the Lee's Discount Liquor shooting. If a clear case came in front of you with a death penalty charge attached to it, would you legislate from the bench or would you allow the death penalty to move forward?
Well, the district attorney is the one that decides whether the death penalty is going to be sought. And so they file a notice that they're going to seek the death penalty. I absolutely would not legislate from the bench. I don't even know that I would have any authority unless there was some kind of defect in the notice of seeking the death penalty. You know, it's a separation of powers issue. The district attorney is the one that has all the, power in order to seek that. And once it is sought, there's lots of rules and protections that come in place. Those are very, very difficult cases. I've had cases, I've never heard that statistic that it's 11 crimes before they commit the first homicide, because I see a lot of cases where they commit a homicide and they have no prior criminal history. And so I guess it runs, the gamut. But no, I believe my job is to interpret the law as written. I'm not a legislator. And I would absolutely not legislate from the bench. I don't believe in that.
So as a veteran panel, we value performance reviews, accountability, and respect. For the past 3 journal surveys, you received ratings below 50%, including low ratings in preparedness, courtesy, and respect. How do you respond to the specific recurring criticisms of what changes have you made in the recently to address the concerns of the legal community?
Are you sure that's me?
That's what I have for you, yes.
And these are the RJ and the very last one. Well, I can tell you, I don't go into the courtroom unless I am prepared. People that appear in front of me, they get treated with respect and dignity. I believe in being courteous. I mean, I would never go in the courtroom without being prepared. I take what I do extremely serious. I know that the lawyers prepare. They have clients that are there, and I think it's important. The judge should be the one that's the most prepared on the bench. I read the pleadings. I really enjoy the practice of law. I enjoy lawyers. I enjoy lawyers appearing in front of me. And so, I believe I treat everybody with respect and courtesy. And I expect the same in return. I really love what I'm doing. And I really do believe in treating people with respect and dignity when they come in the courtroom. I think the courtroom is a very formal place to be. And I think that you act a certain way in there, almost with a sense of reverence because of the importance of the things that we do in the courtroom. And so, when I go in the courtroom, I mean, sometimes I go in the courtroom and I'm so nervous because of the things that we do. And it's hard to believe that after all these years that you still get nervous. But I think it's good because I understand the significance of the importance of the things that we do in the courtroom. Thank you.
I'll pull my stuff. I'll reconfirm what I had to make sure you had the right person, in fairness.
No problem.
Yadasha Jones, Veterans in Politics. With your years on the bench, how have you changed your approach to sentencing and probate rules over time?
Sentencing and probation, like when you're sentencing somebody, whether you're determining whether they go to prison or whether they get probation.
Right.
You know, I think with the more experience that you have, I think it makes you a better at your job and better at determining, those things. Taking someone's freedom away is extraordinarily serious, in my opinion. And so when you go in there to make that type of decision, I think that you have to be prepared. You have to read everything. You have to consider the underlying facts. You have to consider everything that is in front of you. I do think that over the years, I have gotten better, and I think it's experience, maturity. You see more things. You're able to balance, the considerations. And, I think it's really just with experience and preparedness that you get better. And taking the fact that, someone's freedom is on the line. You have someone's freedom is on the line, and then you have victims that have been affected by violent crime. It's very, very important to make those decisions with the seriousness that those decisions require.
Andre Haynes, Armed Forces Chamber, wanted to correct for the record, Judge, you received 74.2% rating from the RJ.
Yeah, I thought that was...
My question
That was a
is,
good one. You woke me up.
My question is, under NRS 200, how do you evaluate sentencing factors in serious felony cases?
Well, you go through the factors. Before you go to sentence someone, you get what's called a pre-sentencing investigation report. Parole and Probation prepares it. It's required by statute. It has a lot of information in there. I rely on that. Sometimes I do extra research, and if they have other case numbers that are in the 8th Judicial District Court or in Justice Court, I can go look at those cases. If they picked up cases pending sentencing, I can look at those cases, read police reports. Also, attorneys, a lot of the times, they will prepare sentencing memorandums. In my opinion, the more information you have, because you can't really consider factors unless you have some factual basis to consider the factors prior to sentencing. I think the more information, the better. I try to be as prepared as possible when I go in the courtroom. However, sometimes you hear things in the courtroom that you didn't know. Each side has an opportunity to speak. I think it's very important what the defendant has to say. Victims have an opportunity to speak. Sometimes something they say changes your mind, sways you because it's something you didn't know. And I think the more information you have, the better it is to consider those factors. I think sentencing is one of the most serious things that we do. And I do approach each one with, I think, the seriousness and the reverence that it requires. Because my freedom is probably my most valuable asset, and so I try to do it the way I would want someone to consider it if it was me or someone I love that was standing in front of them.
J.P. Edwards, excuse me, J.P. Edwards, Armed Forces Chamber. Along that same lines, how do you interpret your role in managing courtroom efficiency without sacrificing litigants' due process?
You know, that's a really, really good question because I think everybody has the opportunity to be heard. However, efficiency and moving your cases along. You know, my calendars start in the morning, and then if you're in trial, I usually like to start trial at 10 or 10:30. So that's a really, it's a crunch time. And so you really want people to be heard. You want the attorneys to show up and be on time so that you can call the cases. But I'm going to tell you, if there's somebody there and they're speaking to me, it's a victim or a defendant wants to speak, I'm going to let them speak. I just do not believe in cutting people off. When I was younger in my career, one of my colleagues, it was a pretty significant case, and I think it involved a DUI death, and there were a lot of victim speakers, and at some point, like, victims were not allowed to speak because of time. You know, my colleague said, I've got trial, we've got to move along, I can't hear. And that really, really affected me. And I thought, you know what? Sometimes there's things that are more important. And I thought letting people be heard, all these years listening to victims speak in court, it is very therapeutic for them. I don't think there's anything about closure when you're a victim of a violent crime. But sometimes I think they just need to let it all out. And I think it's my job to allow that and to listen to that. So I think it is a balancing, but I will never cut anybody off. I will let them speak. I will let them say what they need to say. This is their one and only time. And, a lot of the times the criminal justice system they don't look at it as being like really fun or very favorable to them. And so at this point, when they get to speak, I want that to be a good experience. I want them to be able to have the time that they need, and I want them to be able to express what they need to express to the court. I think that's very important.
So recently you've seen judges try to be and pretend to be social justice warriors. Justice doesn't ever need a presupposition to it. Justice is justice. It doesn't need social justice, racial justice, anything like that. We have a sitting Supreme Court justice who, when she sees pedophile cases, 70% of the time, she will go with the lesser than recommended sentence from the attorneys. So if they say 24 months, she'll give a pedophile 12 because it's at her discretion. You have things at your discretion. If the victims and people who are hurt by these crimes come to you and they have a plea agreement, will you go with the plea agreement or will you go with lesser sentences because of a sob story that's given to you?
Okay, generally I go with the plea agreements. I mean, our criminal justice system works based on plea agreements. I mean, probably 90% of our cases, they're resolved through plea agreements. That's not to say that I'm going to be a rubber stamp for anybody. I'm going to review that guilty plea agreement. If there are issues in that guilty plea agreement that I have a problem with, I'm going to bring them to the bench and I'm going to say, I'm not comfortable with this. Why would you do this? You're going to have to give me some reasons. And you know what? Generally, they can give you the reasons for the plea agreement. And I'm not sure I've ever blown up a plea agreement, to tell you the truth, but I will get comfortable with it. I will make sure that the attorneys, give me the information that I need in order to feel comfortable. Because at the end of the day, I'm the one that has to do it. But no, I don't recall ever where I've gotten a plea agreement and then given somebody, I might have given somebody more, but not less.
I won't go back to the previous question, but I do have conflicting information, so we can table that for another time. In fairness, let's see. I'll ask the same question. So let's see here. Come back to me, please.
Okay. In Clark County, some people believe judges in Department 12 have been inconsistent, or too lenient, too harsh in sentencing? Do you believe that criticism is fair? And what specific changes in your own sentencing record will prove you to be different?
Too lenient and too harsh?
Being too lenient and or too harsh.
And or too harsh. Well, I absolutely think criticism is appropriate. I like to criticize my public officials. I'm not immune from that. And so I think that you have to listen to the criticism, and you have to, usually there's some truth in criticism. And so as I've gotten older, I have more self-awareness, and, I like to take that criticism and, be honest with myself and see, are there things that I can do to improve? I don't know that I've ever been called too lenient, but I would consider that. I think criticism is fair. This is what I signed up for. You're a public official, and you got to be able to take the criticism. But I also think you have to have the self-awareness and the ability to reflect and say, yeah, maybe I do need to work on this, or maybe I do need to work on that. And so I'm open to criticism. I know I can always do better. I try to do better, but I'm not immune from it.
Andre Haynes, Armed Forces Chamber. Explain the bail considerations under Nevada law and how you balance public safety versus the presumption of innocence.
Okay, that's always interesting because you do have to start out with the person has a presumption of innocence, and everyone's entitled to bail unless they are charged with first-degree murder. If they're charged with first-degree murder and you can make a finding that the proof is evident and the presumption is great, you can hold somebody without bail pending trial. Other than that, everyone's entitled to bail. The Supreme Court came out with a decision, we call it a Valdez-Jimenez hearing, and those are usually done in justice court. I do some if they're asking for a change in bail, and that's a hearing. It comes right in the very beginning, and both sides have an opportunity to be heard, and the presumption is really in favor of releasing the person with conditions sufficient to protect the public and guarantee that they come back. And it's not necessarily money. Can you put the person on electronic monitoring? Can you put them on some type of supervised release such that we can protect the public, the victims of the crime, and we can assure that they're going to return to court? Judges can consider bail, and you consider, how long have they lived in the community? Do they have anybody there, sticking up for them, saying they're going to come live with me? What's their age? Do they work? Are they stable? The underlying facts, you have to consider the victim. If you release this person, is the victim going to be in danger? So depending on, like if it's a stalking crime and you have information from the victim, I'm afraid if you let this person out, they're going to do this, this, and this. Well, the judge can, no contact. You can have no contact with, you can put them on electronic monitoring and say they can have no contact with the victim. And then the house arrest division, they know where they're not allowed to have contact with, and they can set the GPS up accordingly. But there's several, basically everything. You can consider everything at that time. What I would look at, how long have they lived in this community? Someone that has lived in this community their entire life, went to school here, has family here, has roots here, that's going to be significant. Versus somebody that was here on vacation for the weekend and they live back east and they have no roots here. That's going to be, you're going to have to balance that. Do they have a job? Are they employed? Are they married? Are they single? Do they have children? How stable are they? You're just looking at factors that are going to guarantee people come back, but you have to also protect the public, because sometimes people are, they're charged with significant offenses, and you have to balance those factors with, and they are entitled to the presumption of innocence. And so, and we can't, you can't fill up all the jails with people pending, resolution of their cases either. So I think people that commit violent offenses, I think those are ones you have to, give more and serious consideration. Nonviolent offenses, I think that you could release them with sufficient, parameters, electronic monitoring, check-in. We have different levels of monitoring. And you know what? It seems to be working pretty well. People generally do come back to court. You don't come back to court, you get a warrant. Then you got to look over your shoulder. I wouldn't want to be doing that. And generally, we do have people, they come back to court. They want to resolve their cases.
J.P. Edwards, Armed Forces Chamber. How would you respond if a high-profile defendant publicly criticizes your courtroom conduct during trial?
I've had that happen plenty of times. I think first of all, people criticize us all the time. I try not to, especially when I'm in trial, I don't watch any of the coverage. I just like to, I've got my game, I'm in my game plan. I've got my, I'm in the zone doing the trial. That's noise to me. Unless it's going to affect me and what I'm doing then, I don't really read it. I don't really get concerned about it. Usually I find out because somebody else tells me about it. But I think the longer you've been on the bench, I think it becomes easier to take the criticism. And you know what? This is what we signed up for. I would do nothing. I would do nothing. They're entitled, a defendant's entitled to criticize me. Again, I would reflect, is there any truth to it? But I would probably do nothing.
So, like I said earlier, on average, they'll commit 11 crimes before they commit their first murder or felony, things like that. Also, the recidivism rate usually tends to drop after a male has turned 27 years of age due to mental competency and things like that. But at what point do you think judges need to be held accountable for continuously allowing violent felons back into the communities that they're harming before they do finally commit their first murder?
I think judges should always be accountable for their decisions. And I think it's important for the public to be aware of that. And you seem like you observe court a lot. And I think it's extremely important for people like you to observe court and be able to report to the community. I think judges should always be accountable. I don't even think it has to get to that extent. I think judges are accountable for every decision that they make. And you know what? It's a really heavy burden, and I think about that all the time. If your decision, if that person goes out and harms someone in the community, that's a big responsibility. And that's why these decisions need to be made, reverently, with preparedness, and they need to be taken serious. I care about my community members. I was born and raised in this community. I'm a 5th generation native Nevadan. I care deeply about this community, and I care deeply about, public safety and the people that I live in my community with.
So NRS 5.057 directs consideration of military service during sentencing. NRS 48.015 and 48.025 state that military records and service-related trauma can be admissible as relevant evidence. How do you apply these statutes when you're making your decisions?
I think it's very important. And in our pre-sentencing investigation, we always have information about prior military experience. I have great respect for people that have served in the military. And I'm aware enough and have lived long enough to know that there are certain things that come with military service, that the court should consider. We have a veterans court now that I think is tremendous and is very helpful. Probably should have had it a long time ago. But I would always consider someone's military service. I think it would be a mitigator in, what is presented to me. And I think it's an important factor to consider in sentencing. Always, even before Veterans Court, that was something that I would consider. I think it's very important. Someone that served our country and then they're having issues after the fact, there's usually a reason for that. And you try to get them to the place that they need to get to in order to get the help. The problem is, there's not enough. I think that the government needs to do more, but the federal government needs to do more to protect our veterans and to have benefits and to have things for them to do. Of all the people, veterans are the ones, we should really, really take care of and protect.
Yadasha Jones, Veterans in Politics. If you've seen a pattern of certain attorneys or agencies getting home court advantage in your department, how will you dismantle that favoritism in practice, not just in words?
Home court advantage, meaning like attorneys I would hope that doesn't happen. I try very hard. I've been on the bench a long time, and so you get to know the attorneys. And there's some that appear in front of you almost every time you're in court. Right. You have the same type of people. You try. I hope I don't do that. I try to reflect and consider, because you don't even want the perception of, home court advantage. When we first moved over to the Regional Justice Center, one of the things that I thought was important is that I didn't even think there should be a perception that someone's getting favorable treatment. The back hallway and back of the courtroom, attorneys were back there. They would walk back and forth, and there were DAs, there were, public defenders. And, I would go into court. We were all kind of coming in the same doors. And I knew immediately, I was like, what does that look like to people in the courtroom? That is not right. Now, I've taken a lot of heat for it, but I have shut that hallway off. I don't allow any attorneys to come down that hallway to enter into the courtroom. When they're in the courtroom, I don't allow them to exit the courtroom. It's very important to me for there not even to be a perception that someone's getting treated fairly. And I thought, how would I feel if I'm sitting in here waiting for my case to be called and the judge and the attorney come walking in and they're coming in the same door? Even though I was in my office, they're in the hallway, we haven't interacted at all. The perception is that we're back there, colluding or talking or doing something that's not right. So I think it's important to even make sure the perception is not there. And I've taken a lot of heat for that, because they love to go in that back hallway and they love to go when they're in court. And I really strictly enforce that. I get asked all the time, can we, and I say, no, I'm sorry, because then you're defeating the whole purpose. If you shut the hallway off and then you let certain people go back, you're defeating the whole purpose. But I've stuck to that. That's a hard line. I won't deviate on that. And I've taken a lot of heat for it.
Andre Haynes, Armed Forces Chamber. Why should voters support you instead of your opponent?
I have 27 years of experience. I have 24 years in district court. I have done civil. I did civil for about 18 years. It's only for about the last, I think 8 years that I have done all criminal. It's the first time in my career where I'd had an all criminal docket. And so my docket is like half and half. Half of it are just homicides and half are just regular, felonies and gross misdemeanors. I have probably presided over every type of case that's filed in the district court. Right now, I preside over the most serious cases that are filed in the district court. First-degree murder, all the murder cases, so I basically get 25% because they're split up between 4 judges. And we did that because those cases need to have, they need to be dealt with. You need to have the time to deal with them, and they wanted us to specialize. And so as 4 judges, we specialize in, homicide cases and getting those cases to trial. And I think we've done a really good job because there was a pretty big backlog of getting those cases to trial, getting them resolved or getting them tried. And, homicide cases are different in that a lot of them do go to trial, whereas regular criminal cases, a lot of those resolve. We're doing we put a lot of effort into getting them to resolve, but sometimes, like for instance, if the death penalty is being sought, there's not a lot of room for plea agreements. And so sometimes those cases have to go forward. But I can't think of a case that's filed in the district court besides family, because we don't do any of that I've not presided over. I had court administration pull my stats recently, because people ask me all the time how many jury trials I've done. I presided over 480 jury trials, so 2 verdict. I wouldn't even have believed that if someone told me it was that much. I have a lot of experience. I truly have a passion for what I do. I love the law. This might sound crazy. I love the lawyers. I love the interaction. I feel strongly about what I do. And again, I care so much about the community and public safety. And I would love to have another 6 years.
J.P. Edwards, Armed Forces Chamber. So going off of that statement, based on Mrs. Jones' question, let's take it to the front of the courtroom. Describe your approach to maintaining decorum when attorneys engage in repeated speaking objections or grandstanding.
Well, there wouldn't be repeated speaking objections. There might be one, and I would say, okay, we don't do speaking objections, and that's important, especially if you have a jury in the room, because if you're doing a speaking objection, you're defeating the whole purpose because the jury is hearing, and sometimes I think that's done purposeful. And so I will say we don't do speaking objections. Objections can be stated in 1 or 2 words, and that is true. And if I need more information, because usually you understand what the objection is, if I need more information, I will have you approach the bench. We will do it outside the presence of the jury panel, because the rules of evidence are meant so that the jury only hears appropriate evidence. So I do not allow, I would shut that down immediately. And I've never had a problem with shutting that down.
Frank Friends, Veterans of Politics. So again, you got these judges legislating from the bench, these social justice warriors. Let's say a case came in front of you, violent criminal case, but they happen to be an illegal immigrant. And DHS or ICE reach out to you and say, hey, as soon as you're done with this, hand them on over. They're coming with us. Are you going to object or try to hide or sneak them out the back or legislate from the bench that this person cannot go with the proper authorities? Because their due process for illegal immigrants is not a trial. It's you're illegal, you're gone. That's the due process that is due to them. Will you uphold that, or will you try to obstruct DHS and ICE from grabbing these people?
That would be a crime if I did that. And I feel strongly, it doesn't matter what I feel personally. I mean, if there's a DHS hold, no, I'm not going to interfere in that at all, no matter how I feel about it. And my feelings and my opinion are irrelevant in that situation. And I know we've had cases across the country, and so I've had an opportunity to think about that. I would never do that. If you believe in the rule of law, you would not do that. Because the rule of law is it doesn't change, and it doesn't matter what your opinions are, what your feelings are. I would uphold the rule of law. I'm not going to obstruct the federal government and break the law. What does that make me? It wouldn't make me a very good judge.
There was a charm, all right. So a lot of people don't understand that outside of presiding on the bench, you also, or at least judges are managers of the staff that support them. So based on your judicial philosophy and how do you manage your courtroom, the staff, the bailiffs, the clerk, all those people that support the whole courtroom operation?
That's a really good question. And I think I've gotten a lot better at that over the years. Right now, the staff that I have, all of them together, I have felt the most comfortable with in my entire career. I work with really, really good people that care about what they do, that are public servants. But if I have a problem, I take care of it. It's important to me that people are treated with respect and dignity. Jurors, when jurors come, I don't want to waste their time. People are here against their will. They're here pursuant to court order. I want to get them in and out as quickly as possible. Sometimes you have people that are kind of rude to the jurors. I will not tolerate that. I mean, it's very important to me that jurors get treated with respect and dignity above anything else. Because of course we want jurors to come back. We want them to be able to serve, because without them, we could not function. The wheels of justice would come to a screeching halt. So sometimes things come to your attention, and of course I like to watch and see what's going on. But the staff I work with, they know my philosophy. They know how important it is to me for people to do their jobs, to do them appropriately, and to treat people. When we're in the courtroom, very, very important to me that everybody gets treated with respect and dignity. When the clerk talks to attorneys, you're going to talk to them with the respect they deserve. And, I'm going to expect the attorneys to do the same. The court marshal, it's his job to, make sure that the courtroom is secure. If that person is doing their job, I can just conduct court, because if something's going on, I shouldn't even know about it, because the court marshal is taking care of it before it even interrupts court. And quite frankly, that's pretty much the way it goes. I mean, I feel very, very fortunate, because sometimes if you have someone missing in your staff, that's when you notice it, because maybe the person that's coming in to substitute doesn't know you as well and know what you like, but you really notice it. But I think it's very important. I've gotten better at that as the years have gone by. If there's an issue, I nip it in the bud immediately. the COs, I'm not in charge of the COs. The sheriff is in charge of the COs. But sometimes there are things that you see and hear and you're not going to allow it. And so I think it's important to never, ever, demean someone in front of inmates or anyone else for that matter, because you don't want to do anything to interfere with the security of the courtroom. But I have in the past. I've dealt with it. I deal with it privately. I have the person spoken to. But yeah, there's certain things I just won't. I won't tolerate. And I'm the one that's supposed to, manage the courtroom and make sure that everybody is acting accordingly. Very, very important to me that everybody is treated with respect and dignity, that there's proper decorum. I really think court should be a reverent proceeding. And, I try to make sure that the proceedings are.
You're Dr. Jones, Veterans in Politics. So, do you have an action plan or rehabilitation plan for first-time offenders or young offenders? And if not, would you create one?
First-time offenders, especially young people, something that's been really, really bothering me is I get a lot of young minors that have committed violent, serious offenses, including murder. And when I look out at these, it makes me emotional even just talking about it because, I look out at these young people that have made a devastating choice that just, spirals their life out of control. And it is just so obvious to me that they have not even thought, that they don't even have the ability because they're so young to even think about, how this is going to affect them. Right. I think it's a big problem in our community. Yes. I think it's my job to sound the alarm. And so I sound the alarm as much as I can that we have problems with juveniles committing violent crimes and we got to do something about it. I don't know what the answer is, but I do think there has to be intervention and people have to be made aware of it. And there really need to be, we need to protect young people. You can't just throw young people away and throw away the key. That's not a civil society. We know it's a problem. We need to intervene and we need to have programs and ways to help these young people. It is very, very, very disheartening. I'm a mom. My kids are all adults. I see these little boys out there. They are little boys to me. They are cute. They look, it pains me more than anything that I have to do to deal with, juveniles and juveniles that don't have one parent sitting in the courtroom. I just can't imagine. Sometimes I think, well, maybe that's why they're here. I couldn't imagine being an adult and facing charges like that and not having someone there for me, let alone being 15 or 16 years old and all that comes around with being 15 or 16 years old and having to stand in front of, adults and have to face these serious consequences. But it's a big problem in our community. I think there needs to be intervention. Things have to be done. But you did ask me about first-time offenders. Of course, first-time offenders, depending on what the case is, of course, we try to, I don't like to send anybody to prison. I think taking someone's freedom away is extremely serious. And it should be, when you just really feel like there's just no other way that you can protect the community. Because the bottom line, I got to protect the community too. I can't let someone out that I know in my heart, this person cannot roam around in civilized society because they just can't control themselves. But first-time offenders, absolutely. I probably would never send a first-time offender to prison except if it was like, some sort of violent crime. Yeah, we try to, especially with drugs. I'm a big believer. If you can get people off drugs and you can get them into an inpatient treatment program and they're willing to take the help and change, you're not going to see them again. We have mental health issues. If you can, and a lot of times you can tell that mental health is creating the problem. You can tell by the underlying facts, like, this is just like not normal. Why would somebody do this? You find out that they have some significant mental health issues. If we can get them into mental health, if we can get them on medication, we're not going to see them again. And so I think it's important to try to look, beyond just the case. We don't want people to commit more crimes. We want them. I would love it if people came here. It was one time. We could get them the help that they needed, and then they didn't have any contact with the criminal justice system ever again. But absolutely, first-time offenders, especially with drugs, we always try to get them into treatment. And not everyone has to go to inpatient treatment. A younger person that hasn't been on drugs for that long, maybe they can do intensive outpatient. But someone that's older, has been on drugs, and they're doing heroin and methamphetamine, that person needs higher level of care. And, we have drug court and we have inpatient treatment to handle those things. And if people are willing to take the help and they're ready, I think we won't see them again. Because if you get the underlying problem, if you get that taken care of, then you don't see them again. And that would make me very happy if we didn't see those first-time offenders again. Oh, the cord came out of my microphone. I don't know if it's still working. Here we go.
There you go.
Did you lose me?
No. Yeah.
Do you want me to talk louder?
You good?
Sorry.
It's all right. It's all right. Let's see.
All right, Judge, and we're
Thank
going
you
to
so
ask you to make a final statement and also share your point of contact information.
Okay, thank you very much. I've thoroughly enjoyed talking to you all this morning. Thank you for giving me the opportunity, and thank you very much for your for educating the public. I think it's very important that the public is educated on judges. People worry about the national elections, the president, the senators. You will be affected by a judge in your community a lot more. You're probably never going to be affected by the president or some of these national elections, but you will at some point in your lifetime be affected by a judge in your community. I think it's important that you become educated on who those people are and that you make those decisions, after researching the judges and seeing what their qualifications are and seeing what their background is, because it's very important, the people that put you in there. A judge can decide when you can see your child. A judge can tell you have to pay certain money. A judge can take your freedom away. A judge can send you to death row. They're very serious things that a judge can do, and you're much more likely to be affected by a judge than anybody else that you vote for. So I think it's very important, and I do appreciate you giving me this platform to speak today. I've been on the bench for 27 years. I have a lot of experience. Again, I've probably presided over every type of case multiple times that is filed in the 8th Judicial District Court. I have a passion for what I do. Public safety is very, very important to me. I was born and raised here. I have 10 siblings that are here that are raising their family. I have grandkids now that are growing up in this community. It's a little different from when I grew up, but I love this community. I love the state of Nevada. I have a deep respect for my community, and I care deeply about my fellow community members, and I want to make sure this community is remaining safe and that I do the job to the best of my ability. I think my website is judgeleavitt.com. They can look me there. You can come down to the 8th Judicial District Court, Department 12. I'm on the 14th floor, courtroom 14D. You get off the elevator, go to the right. When you come up, there's courtrooms on the left and the right. Make a right, go all the way down to the end of the hallway. I think it's important. I love when people come to watch court. I think that's good. I'm not afraid of transparency. We broadcast on Zoom, pretty much all of our calendars. You can get a Zoom link and watch court. You can come in and watch a trial. I think it's important for the community to do that, and I would welcome it. Thank you.
Thank you very much, Judge. This is the Joint Veterans Endorsement Interviews for Judicial Candidates, sponsored by Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds from Department 29. Thank you for watching, and thank you for listening. Have a great day.